Well, let's go. Kyle. Just so we can. Yo, Kyle. Oh my God, dude, one of my top listeners.
Yeah.
That's all right.
Yeah. Was it you that texted out about wanting to study for this class?
Yes, but it wasn't wrong weekend for you.
No,
I was
no.
being like really like.
Ambitious, no, I get that. But I mean, I think if you guys want to start like getting a group together, I'd be down.
So I want to do it this week.
Yeah.
Yeah.
This coming week.
Well,
Or this
Saturday.
this Saturday.
I was gonna invite you over my room.
Yeah.
Everyone brings me.
And just like talk over concepts in here. Yeah, because I feel like I'm kind of having very like piecemeal, like looking at the cases, but I'm not understanding the whole thing. So I want to catch it before it becomes an actual problem.
Yeah. How does this class compare to other classes?
No. This is not.
Yeah. I mean, both in here and towards, I'm having a difficult idea understanding how we're going to be tested. Like, I don't
Right.
understand.
Like it's
that
really
for sure.
fact pattern running
But
through
when
and
he's
through.
talking, the people understand what he's saying.
Yeah.
Like common law,
It's like a
no
toss
idea
up.
what regulations.
Like, for this case, like, what rules should we follow? Like, how do we understand?
I think it's just basically the idea that like the law of the sovereign of the place where the land's located is like whatever it is what governs.
Yeah, I think it's more so like foundation.
But,
Like you were saying, like this is foundation. That's why we. I know, that's really important.
I'll tell you.
Well, let's test and see if they actually clean it. Now that would be interesting. You know what's going on?
Oh, there's
Is it mergers and acquisitions stuff?
Well, no thanks.
Yeah, of course. If you see me around or like, hey, have any questions? I can like give you my email if you have any questions. Yeah.
Hello there. How are you?
Fine, how are you? So, you want to use the lectern or sit down when we speak? Do you have a preference? I don't care.
Well, I actually was kind of where
Our mics. Turn this on. If I just clip this. Yep, it's live. Thank you. Anything embarrassing to say? You should have said.
Hi. Nice to meet you. Thanks for inviting me. Very pleased to be
We've
here.
got a long line.
It looks like
Must have good food.
Well, good speakers and good food is a nice combination. All right. Would you I told them no PowerPoint. No PowerPoint. Right. And then the time, what did we say, 15?
So I think what we'll do is 15, 15, and then 8 to 10, the second iteration.
Okay.
And we'll open up for 10 to 15 Q&A.
Okay. Okay, that sounds good. And we have the room until when?
We are absolutely kicked out by 1:45. We usually like to finish around
1:30.
1:35.
It's actually my class that's in here at 1:45.
Oh.
So
They'll kick us out.
you've got to be out.
Well, we can just extend
I
it,
can't
too.
be out, but you've got to be.
We'll just extend it. This is part of your class.
Right.
And you'll be in charge of turning the mics on, or they are already on?
They are on already.
Fantastic.
But thank you for the reminder. That's one of the things that's easy to forget.
It is, actually. I was watching one of the sports anchors do it Friday during his live broadcast.
Right, even the pros.
you do anything with her now? No. Okay. Oh, already. Oh, okay. Yeah. Okay. I can't imagine.
So these aren't, well, those are on.
Yeah. Now what I think is not active are the student mics. So the recording will probably not pick up their questions very well. Which usually can be handled in the way you answer them.
Right. Well, it does look like a good group out there.
Yeah. Yeah. We have, in recent years, this has probably happened at your law school as well. You are a private law school, right? Or are you not? You're not.
No.
So it's state of Texas, or is it a municipal?
It's stayed. It's just not. It's just not the same board of regents that the University of Texas system has.
Not part of that system.
Yeah.
So, well, I don't know. That could have an impact on it. I think at a private school with tuition like we have some resources, and one of the ways we spend them is on middle of the day enrichment. So there's one or two things going on. I'm actually missing a job talk by a candidate that was not scheduled until after this was.
Oh my.
So I didn't feel like I could stiff the Federalist Society. But I actually should be upstairs listening to that. And there's something next door with pizza, and this is, I don't know what they have, burritos or something. We'll know when we start seeing, pheasant under glass that things have gone too far.
Yeah. We have pretty good turnout at our events. If anything, it seems like we sometimes have.
Yeah. And it's hardly a week goes by when there isn't an unfortunate choice.
That's right. That's the way it is at Houston.
Among events that
at Washington and Lee, I felt like they scheduled fewer events, and that helped with the attendance.
Mm-hmm. Yeah.
Thank you.
It wasn't a long trip for me. Right.
Yeah.
hosting us? I presume someone is. If not, I'll introduce myself as the first speaker. I'm comfortable doing that with an audience that includes some of my own students.
Sure.
And then I'll introduce you. And I obviously can identify you with the University of Houston and having visited at Washington Lee. What colleges and law school?
The three would be undergrad from Oklahoma State University, Harvard Law School, and then JD, and then Dallas Theological Seminary, Master of Arts.
So are you a sports fan? Do you follow University of Houston?
The answer to your first question is yes. The answer to your second question is somewhat. Probably what I like the most is, in terms of spectator sports, is college football. I will get into college basketball around the road to the Final Four, the big NCAA tournament. But all season long, I like watching college football. I don't really get into professional football. Now, professional basketball, by the time it's playoff time, I'll start watching. So.
Myself, I don't watch the NFL much. I do like college football a lot.
Yeah, I think it's a lot. Yes, it is. It's a lot of fun, and there's a.
It may be a dying game because of injury problems, and the injury problems are gross. I mean, if you watch a game live, you sort of are exposed in a way that you're not on TV, because on TV they stop the action.
Right.
That's when they do some commercials, but you
Right.
see that it's a rare game that action isn't stopped for 5 minutes, half a dozen
Yes.
times to cart people off the field.
That's true, and I will be perfectly happy if my son never wants to play football. I started playing football, Rich, when I was like in 5th grade.
Yeah, me too.
And then, but after my freshman year in high school, I quit. I was tired of it.
Well, I played freshman and sophomore years in high school, and then we moved to a school that was much larger, and I was undersized then.
Yeah.
Bigger now, but undersized then.
Yeah.
And thought I had no chance of impressing the coaches enough to crack a team that was had a roster of 100 people on it already, so I didn't bother. But
Well, when I was a freshman, the coaches thought I had more ability in football than basketball. But I liked basketball much better. And if your heart's not in football, it's not a good sport to be participating
you
in.
probably had to play line. If you're a shot putter, that's
I was on the line.
I was playing defensive back. I got to tell you, defensive back is a lot of fun.
Yeah.
Yeah. You know, it's a significantly intellectual activity, really, because you're kind of the last line of defense.
It's true.
You've got to be reading.
Yeah. You have to make decisions
situations
quickly.
and figuring things out and honing your instincts.
But you also have to run a lot.
Yeah, you run a lot. But if that's what you're mostly good at anyway.
Yeah, that's true. That's not a problem. I was better at pushing, running.
I did enjoy tackling, though, I gotta say.
Yeah.
I was not big, but I threw myself into it.
Yeah.
It's probably good I stopped playing as a sophomore in high school. I could have continued and be brain dead by now.
I like
Because I was stupidly fearless. I mean, really.
Really?
I would. You know, I was pretty sure. You know, if I encountered sometimes running backs who probably weighed 75 pounds more than I did, and I was still pretty sure I could bring them down if I just got in front of them and grabbed them and hung on.
Right.
You know, if they didn't, they would fall over me, on top of me in many cases.
But they would come
come
down.
down.
Yeah.
And if occasionally they didn't, if I hung on, I slowed them down enough that others
Someone
would
else
come
get
down, and they would be tackled. But in many cases, the big guys wouldn't even try to avoid me when it came to that because of the assumption that I'd eventually get out of the way or that they could just run over me. And I should have probably let them do that. I probably took too many frontal hits from people much larger than I was for my own good. But maybe I dodged a bullet. Or, some of it is just luck, just random variation. Just not getting a knee to the helmet or something like that. I don't think I had any concussions.
Did you ever play basketball?
Yeah, I played basketball too. Same story, actually. I played in my first 2 years of high school and then not at the big school. I played baseball in college. That was my one college person.
Oh, you did?
Yeah. But at
Your
University
spot?
of Chicago. So I was an infielder. I thought of myself as a shortstop, but the coach thought of me as a third baseman. So mostly third base.
My dad
Played a couple games at second base.
My dad actually coached baseball for a bit. He was very good in high school and coached some in Great Bend, Kansas, and then he moved back to farm.
Not every kid is like this, but I was the sports were my life. From the earliest time that I could play them, Little League baseball and things like that, until college, and then even after that. Whenever I could organize a 2-on-2 basketball game or join a softball league or something like that, I did until I continued to play intramural basketball with the law students until I was well
Did you
into my
really?
50s. Yeah. And then at that point I was just too slow. You lose it. You can't get off the floor anymore. You're too slow.
I'm not saying.
There's only so much you can make up in canniness for a loss of sheer athletic skill.
Yeah. Well, we just recently purchased Rex, his first basketball goal, so I've been shooting a little bit lately.
I was a good shooter, good ball handler.
Yeah.
Not much of a rebounder.
I was better at
Adequate perimeter defense, but I couldn't handle the big guys in the
yeah.
middle.
I was better down low, but I wasn't that tall. I'm not that tall.
Well, strength matters.
Yeah, I
too.
could push
I
around.
had neither height nor strength. So.
Yeah. I was a lousy ball handler, though. People could steal it from me. How many children?
Sorry?
How many children?
2, and they're both at Furman University in Greenville, South Carolina.
Mm-hmm.
It's liberal arts college, kind of. So I think in the southeast, the National Liberal Arts Colleges would rank something like this. It would be sort of Davidson, and then a slight notch below that, Washington Elite. And then you drop a bit because there aren't any kind of the next two dozen schools. Richmond, University of Richmond, and then Furman and Wofford, a couple of others that are. And I really believe in the small liberal arts college. A lot of our students come from good small liberal arts colleges.
Mm-hmm.
Where if you do a lot of writing, you get a lot more individual attention from faculty than you do at the big places.
Mm-hmm. I'm sure that's right.
So we're happy with their choice of Furman.
That's
At
not
the
too
time,
far away.
At the time our first daughter decided to go there, the president was a Duke Law School grad, and I knew a bit. You could know not small is his name, and he actually.
Oh, yeah.
Yeah, you do.
He was the dean when I was at
At Washington Elite.
Yeah.
He was also dean at Richmond.
Yeah.
And then went to the presidency of Furman.
Kind of 5-minute warning and 2-minute warning.
Okay.
Okay.
For timing.
Okay, and you're doing the introduction.
I'll do introduction.
Okay.
And then, would you prefer to stand up? I guess you can.
I think I will stand at the podium as I think about it because there's no lectern here, so for ease of seeing my notes.
Hi, everyone.
I know people are still filtering in, but we're going to go ahead and get started. Thank you for coming to our event today, titled Separation of Church and Speech, Rethinking the Tax Exemption for Churches. This is a discussion, not a debate, so there may not be a whole lot of disagreement between panelists. We'll start out with an introduction of our guest speaker, Professor Johnny Rex Buckles. Professor Buckles attended Oklahoma State University, where he earned his bachelor's degree, Harvard Law School, where he was editorial board member of the Harvard Law Review. He has a master's from the Dallas Theological Seminary. He worked as a tax lawyer in Dallas before beginning his career in education. He was a visiting professor at Washington and Lee and is now a professor at the University of Houston Law Center. He has a forthcoming book, Estate Planning Law and Taxation, and he's published numerous law review articles and other works. Professor Richard Schmalbeck is a professor here at Duke. He earned his undergraduate degree from the University of Chicago and also his law degree from the University of Chicago Law School, where he served as associate editor of the University of Chicago Law Review. Prior to teaching, he practiced tax law in Washington, D.C. He authors the Federal Tax Casebook with Professor Zelenak and has published numerous articles and other works. We're going to start with Professor Schmalbeck. He'll speak for 15 minutes, followed by Professor Buckles for 15 minutes, after which we'll have two response iterations of about 8 to 10 minutes each, and then we'll finish up with a 10 to 15 minute question and answer period. Please join me in welcoming our speakers today.
Thank you, Michael, and thanks to the Federalist Society for sponsoring this. So I wrote a paper a few years ago about churches and political speech. I haven't tried to publish it yet because I'm still not happy with it, but I'm happy to circulate a draft to any of you who are interested. I shouldn't be hard to find, so just send me an email if you'd like a copy of that, and then I'll send it back to you. My interest in the subject was piqued by an audit program undertaken by the Internal Revenue Service in 2005, following the 2004 election. They apparently audited about 50 churches, and most of these are unknown because the IRS doesn't announce these audits. They don't publicize the names of the targets of the audits, and most of the targets don't see any reason to reveal it themselves. So we don't know what the mix was or really much of anything about these audits, except in one prominent case. One of the targets was All Saints Church, a very liberal Episcopal or Anglican church in Pasadena, California, which was outraged at being the target of the audit and publicized it and publicized their vigorous defense of what their activities had been. I'll get back to that in a second, but as background, it's useful for you to know, I think, that all charitable organizations, including churches, are by statute prohibited from participating in electoral campaigns, and also can engage in no more than insubstantial amounts of lobbying. That's in Section 501c3, which defines the organizations that are entitled to exemption as charitable, religious, educational, and a few other things. The All Saints pastor emeritus delivered a sermon on the Sunday before the 2004 election that described an imaginary debate among George Bush, John Kerry, and Jesus. And right, the smart money would always be on Jesus in this array, and indeed he was the clear winner. So the interest turned to who placed, who turned out second, and I think you'd have to say that it was clearly John Kerry. I should mention that this, the last time I checked, this sermon was still on the All Saints website, but I also have a copy available, so if you want to see what was in the sermon, I can send you that also. So I think Kerry won, or placed second, but mostly by default, I think. George Bush had served a term already, during which he passed 2 tax cuts that had substantial benefits for high-income Americans. You could call them tax cuts for the rich if you were so inclined. And, of course, he had begun a war in Iraq. And so the sermon was a kind of anti-war social justice sermon, and so President Bush took some hits from the pastor for those things. Kerry was sort of a bystander. He hadn't done those things, and so didn't suffer much in the way of criticism. And so, as I said, was probably kind of the winner by default. You couldn't come away from the sermon without a clear sense of who the pastor was likely to vote for. But was this campaign participation of a sort that was prohibited by Section 501c3? The IRS thought that it was, and apparently still thinks so. They closed the audit without any action, but wrote a letter saying, "Don't do this again." That's where the matter essentially stands. Was it campaign participation? I teach a nonprofits course here, and we talk about this a little bit, this case, and I actually think it was not campaign participation, but I take a kind of plebiscite in the class, and they usually outvote me 2-1 or so on this, thinking that it probably was. I actually did work on the case a little bit, so maybe I have client bias here, but I was actually also interviewed by NPR about it before I did any work on the case, and so I'm on record as being sympathetic with All Saints, even before I had a client interest of any sort in that. But whether or not it was campaign participation, I think most people have some sympathy for the situation of the church, because churches are fundamentally expressive institutions. They talk about values. That is probably the primary thing that churches talk about, and values influence votes. So telling churches that they can't have any contact with a political campaign, can't express opinions about a political campaign, is a little like telling them you can talk about values except when it might actually matter. And that's not an attractive position for the government to be in. I should mention that this, it's probably obvious, but this does have some partisan salience. There are liberal churches and conservative ones and mixed ones, but not probably in equal numbers. There are surveys that show that a substantial majority of people who report that they attend church every week also report that they lean Republican. So I think Democrats are particularly concerned about church participation, although, again, I emphasize that, All Saints itself was a left-of-center church. We know the African-American community has a pretty long tradition of bumping right up against whatever line there is on campaign participation. So this cuts both ways, but a little more heavily in favor probably of Republicans if the political speech shackles were removed from churches generally. Now, it would be easy to do that. It would be easy to unmuzzle churches from a legislative draftsmanship viewpoint. All you'd have to do is delete the language from 501c3 that restricts this. And if you didn't want to do it for all charities, you could leave the language in 501c3 but add an exception for speech by churches. That latter approach has actually been proposed. It's proposed annually, in fact, by one of our neighboring congressmen, not from this immediate area, but Walter Jones, who represents a district that's begins about 50 miles east of here, annually introduces a bill which annually lies in repose on the the Ways and Means Committee floor without actually being moved to general debate within the House. So it doesn't go anywhere, but he keeps proposing it anyway. But before we think about that solution or other solutions, I should mention that there's another code section that is important here, which is Section 170, which allows a deduction for contribution to 501c3 organizations, including churches. And the effect of that is to offer a subsidy in proportion to the tax rate of the donor. So the highest marginal tax rate we have for individuals in our system currently is very close to 40%. It would actually be a little higher than 40% if you include state income tax deductions, which are routinely available for charitable contributions as well. And what that means is that when a rich person contributes $1 to a church or another charity, his tax bill is reduced by 40 cents, sort of a matching grant program, if you will. Or you could think of it as a 40% discount on the cost of supporting that taxpayer's church or other organization of choice. So if we didn't limit political speech by churches, we would be, in effect, subsidizing political speech by churches. And there are some reasons to be concerned about that. I think the biggest one is that it creates an unlevel playing field, because under present law, both lobbying and campaign activity are, with very rare exceptions, not deductible. Section 162 prohibits a business expense deduction for businesses. They are not permitted to deduct things like lobbying costs by explicit provision of the Internal Revenue Code. If they belong to trade associations, the trade association dues that they pay might be generally deductible, but the trade association is supposed to segregate the funds that it spends on lobbying and notify the donors to the trade association or the members that part of their membership fees are not deductible. And individuals are not permitted to deduct those costs. You as a citizen are permitted to petition government for redress of your grievances, of course. That's one of your primary constitutional rights, but you aren't permitted to deduct the costs of doing that. So if you want to place a one-page ad in the New York Times or the Wall Street Journal, you're going to pay for that, and you're not going to get a deduction. There's not going to be a 40% subsidy by the federal government for that expenditure. So if 501c3 did not contain this prohibition on churches, it would be possible to contribute to a cooperative church or even establish a church for this purpose, deduct the contributions, and use the church as a tax-privileged, a tax-favored campaign mouthpiece. So I think there's a legitimate worry that if the only way to deduct campaign contributions is to funnel them through the church, then people will do that. And I think to the degradation of both our political system and churches. Now, this is especially worrisome because churches are very hard to police. And that's because Congress has treated them with a great deal more deference than they treat other 501c3 organizations, largely out of concerns of excessive entanglement, which the government tries to avoid when it gets close to a religious organization. That's part of the free exercise part of the First Amendment. So, for example, most nonprofit organizations have to apply for recognition of their exemption. There's a 20-page form that they have to file with the IRS in order to be blessed as a qualified 501c3 organization. Churches don't have to do that. Churches are automatically, they enjoy an automatic presumption that they qualify for 501c3. Most nonprofit organizations have to file annual information returns, the Form 990, disclosing not only a substantial amount of their financial information, but also a good deal of operational information. And those returns, like the exemption application itself, are public documents, so people can inspect them and criticize them if they think there's something inappropriate going on. Churches have no filing requirements whatsoever, and hence, obviously, no public inspection exposure with respect to their operations or expenditures. Most organizations, charitable organizations, are subject to random audits. The IRS can just send you a letter, and just like any other taxpayer, and say, we'd like to review this return with you and see if you've done everything appropriately and disclosed everything you are required to disclose. The IRS is permitted to audit churches, but they're subject to some special restrictions in an act called the Church Audit Procedure Act. And it imposes some restrictions on the IRS. The IRS cannot do any sort of summary audit. They have to give the church 15 days' notice that they'd like to talk to them. They have to give them an opportunity for a pre-audit conference that will sort of set the rules for the audit. And I've always enjoyed the definition of church for purposes of the Church Audit Procedure Act. It's probably my favorite definition in the Internal Revenue Code. You probably all have your own, but this one's my favorite. I'll quote Section 7611H. Quote, "The term church includes any organization claiming to be a church." How do you like that one? I think even those not experienced in spotting loopholes consent that there might be one there. Especially taken together, these things make misbehavior by churches very hard for the IRS to even be aware of, much less have any effective control over. And it also makes it attractive for organizations, which of course can be the alter egos of individuals, to claim to have church status, especially when they can achieve church status simply by saying they have it. Getting back to situations like the All Saints situation, since I'm kind of running out of time here, I have to say I am not too worried about sermons on the Sunday before elections. And part of that is based on the somewhat hackneyed metaphor that I imagine you've mostly heard about preaching to the choir. Well, you could hardly think of a more literal application of that than this. What does it mean? If you're not familiar with it, it means basically don't waste your breath arguing for a position that your audience already holds. And that's what I think happens in these churches. You have a church that has a viewpoint that includes probably views about abortion and a number of other things, and these views are generally widely shared by the congregation. If they're not widely shared, and there are some churches, I think some of the mainline churches, Methodists, Lutherans, Presbyterians, that probably have audiences of Democrats and Republicans in their sanctuary on Sundays. Those churches are not actually doing much of this, I think. I think the pastors and others in that church recognize the diverse viewpoints. They're not particularly interested in annoying the 40% or something of their parishioners who might disagree with them and might even seek a different affiliation if they are persistently annoyed by political statements from the pulpit. So I think you don't have those political statements from the pulpit in those kinds of churches. But you do have churches that where most of the parishioners are conservative Republicans. You have certainly African American churches where virtually all of the parishioners are liberal Democrats, except when it comes to some social issues like same-sex marriage. And then it breaks down a little. But still, in most cases, statements that might look like campaign activity take place in the context of situations where they're not going to make a lot of difference because you're talking to people who are already going to vote in the way that you would like them to vote. I don't think they are that influential. So that's not what I worry about. What I worry about is that if the restrictions on political activity were totally removed, you could imagine a church that would offer meeting space and even office space to a candidate or a party. Many churches have buses, a fleet of buses to bring people to services on Sunday. Those buses would be potentially available for registration drives and get out the vote drives and not in an even-handed way. There's a particular vote that you'd be trying to get out if you had a particular viewpoint on the appropriate outcome. There are churches that televise their services. There are churches that consist of little other than televising their services. So those services are reaching a broader audience, and I think if all the limits were removed on political campaign activity, you would likely find that there'd be at least some churches that decided that they might want to step up that effort in the couple of months that preceded an election. And there then you go beyond the relatively harmless preaching to the choir and get to a point where you're basically talking about discharging a substantial part of campaign expenses through the use of a church in ways that generate a 40% subsidy from the federal government, and in ways that are not even-handed, because not every candidate is equally well-positioned to take advantage of church assistance of that sort. And so, as I've said, I think this would degrade both churches and politics. Is there any better solution than simply lifting the speech ban on churches, which I think is terribly problematic for the reasons I've just described? There may be a couple, and one of them is in the paper. I actually suggest that we create a separate tax-exempt category for churches that would allow them to be tax-exempt, but would not allow donors to take charitable contribution deductions for their donations. I would make this elective so that churches could take off the shackles on the speech, but only at the cost of forfeiting the subsidy from the federal government. The part that I'm still playing with on the paper is whether there are any a little less drastic approaches to this, such as having an affiliated nonprofit organization that was not taking charitable contribution deductions and requiring that that organization be the one that engages in politics and not the 501c3 organization getting the charitable contributions. But anyway, I've run out of time about 2 minutes ago, so let me at this point turn it over.
First, Michael, other Federalist Society members, thank you very much for inviting me here today. It is a true pleasure to be speaking with you. It is a true pleasure to be speaking on another panel with Professor Schmalbeck, two-person panel. Though it is, we've served on panel before. It was nice last time. It's nice again. I hope it's not the last time we're able to do this. Let me begin my remarks by giving you a few more anecdotes of the kinds of situations of concern. You heard from your esteemed prof the example of All Saints Episcopal Church. I love the example too. I use it in my very first article on this subject. I've got 3 different ones, which I consider to be interrelated. And so it's the example that I not only begin one article with, but also have begun presentations with as well, because it's fun, right? It's fun to see a pastor posing a hypothetical debate among Kerry and Bush, and then the one whose opinion really matters to Christians. But there are other examples as well. This one came out of the 2004 election cycle. There are some that came out of subsequent ones. So just to give you a little bit more feel for some of the things that have gone on, in June of 2007, having been invited to address the 50th anniversary of the General Synod of the United Church of Christ, fully 1 year before announcing his campaign for the presidency, one United States senator among 60 other platform guests explained the role of his faith and pursuing his calling in life. And the IRS subsequently opened an investigation of the church's role in that event, just with that minimal testimony. The senator would later, of course, become our first African-American president of the United States. A couple months after this event, a Buena Park pastor, his name was Wiley Drake, personally endorsed former Arkansas Governor Mike Huckabee in his presidential bid. I understand he's close to announcing another one. He did this first in a news release and then on his own radio show. And within 6 months, a letter of inquiry from the IRS followed. Now, you will often see Americans United for Separation of Church and State serving as a watchdog in this area and alerting to the IRS of situations that it believes to be of concern. Some examples of institutions that Americans United has called to the attention of the IRS was the Pentecostal Temple Church of God in Las Vegas, Nevada. It shared its pulpit with then Senator Obama, and the pastor expressed support for him. I don't know, he probably called him up on the stage and put his arm around him and gave him a pat on the back and said, he's my man, or something like that. Another target, this one was closer to my home, was the Grace Community Church in Houston, Texas. Not my church, but I've heard of it. A pastor endorsed a congressional hopeful on his personal stationery. That was enough to merit a call to the IRS to try to get them to investigate. Now, in all fairness, this was just the effort of Americans United rather than the IRS itself. I don't believe anything ever came of that personal endorsement. Now, when you think about the kinds of activities that are of concern to the IRS, you see that it reaches far, far beyond the concern that Professor Schmalbeck has, and that I have as well, as I've articulated in prior scholarship, that churches would be used as conduits to fund political campaign. It goes beyond this, the way that the IRS, anyway, interprets the effective ban on participation or intervention in a political campaign on behalf of or in opposition to a candidate for public office. What I would like to do is set forth some major discussion points. At this point, how much time do I have to be reasonably equivalent? 10 minutes? All right. So I'm going to lay out my major points, and then what I'm going to do is reserve maybe 3-4 minutes, if I can, towards the end of this series of my major points, to address a concern that many people have, a concern that Professor Schmalbeck addresses in his paper about whether there is an establishment clause problem with letting churches receive some type of tax preference. But before that, let me just lay out the major points. And most of them, I'm sorry to disappoint if I do, most of them I think are shared by Professor Schmalbeck. But they're not shared by everybody, and so I want to make sure that my position is clear on this. First, the interest of church pastors in freely, plainly, unqualifiedly expressing their religious convictions in regular church worship services involving preaching is a very strong interest. I think it's strong under existing constitutional norms. It's strong under historical precedent. It is strong morally. Their interest in boldly proclaiming what they hold as their religious convictions. No disagreement here on this panel. Many church pastors, my second point, many church pastors, as well as many other people of faith, hold to the religious conviction that the practice of their faith requires engagement with society at large, including both practicing their values and beliefs, and advocating their values, beliefs, and practices. And you can look at numerous movements within the history of not only our country, but the world, where this is proven. Consider the strong Christian contribution to the abolitionist movement in England as well as in this country. Global missions and the humanitarian and evangelistic efforts of great missionary societies, civil rights movement, establishing of hospitals and orphanages and even universities. And more generally, as others have observed, including Professor Schmalbeck in his paper, the work that we now identify as charity was largely carried on by the church for significant portions of history, after Christ anyway. And when you think about the law of charity as it developed after the enactment of the Statute of Charitable Uses in 1601, let's not forget how the English of the time, whose law we borrow from, conceptualized charity. Indeed, the term that is translated love in 1 Corinthians 13 was not so translated in the King James Version of the Bible. You know how it was translated? If you were to, I don't read King James very often, but if you were to read that translation, it would not say love is patient, love is kind. It would say charity. Charity is patient. Charity is kind. It begins, though I speak with the tongues of men and of angels and have not charity, I become a sounding brass or a tinkling cymbal, and goes all the way through to the conclusion. And now abideth faith, hope, charity, these three. But the greatest of these is charity. To do charity, when English-speaking people spoke this way back at the time of the Statute of Charitable Uses, to do charity was to do agape, It was to do God's love, to relate with the love of God, to act on love, to act with love. And of course, the preamble to the statute of charitable uses included within its purview the repair of churches. Later famous cases enunciated the advancement of religion along with other charitable uses. Pimsel case might ring a bell to some of you. And my point is simply this, that religious purposes have long been understood as charitable purposes, as including more broadly charitable purposes as well. And it's not an accident. The church has long been active and in performing and promoting acts of charity as an aspect of faith. Now, related to this point, my third major point, for many to practice their religious faith, to engage in charity as members of a religious community, is to engage society on matters of public policy. For countless people of faith, including pastors, to express their views on contemporary issues of concern, those that occupy the conscience of society, is to express their religious views on the subject. What that means, as for many people of faith, is that social issues, economic issues, medical issues, even political issues are also simultaneously religious issues. They're not easily compartmentalized, a point that Professor Schmalbeck has also acknowledged in his paper. Now, so far, you may be thinking, why are we even having a discussion? Because we agree on everything. Well, so let me push it forward a little bit more, and let me tell you specifically some things that concern me about current law. I'll give you a very broad summary of what I would like to see happen, and then I will address this Establishment Clause issue. Current federal tax law, in my judgment, excessively stifles political speech by pastors and church bodies, particularly as the law is interpreted by the Internal Revenue Service. The service interprets the ban very broadly. So just listen to some of the things that the IRS has come out saying with respect to the ban. The ban prohibits strictly internal communications from a religious leader to church members. The agency applies the ban to remarks made in a Sunday sermon or at an annual meeting, as well as to communications from a leader to members in a church newsletter, to the preaching to the choir point. That's the way the IRS understands the ban. And this is so in the case of the newsletter, even when the church leader personally pays for space and emphasizes that the views expressed are strictly personal. Further, the IRS takes the position that a church may violate the ban without expressly endorsing or opposing a candidate. To illustrate, official, and I'm not just talking about a few random agents who decided they want to, come down on a retired pastor of an Episcopalian church in Pasadena, California. The IRS guidance implies that the hosting of a candidate forum in which candidates are asked to address only a narrow range of issues of primary interest to the church may violate the ban. And the guidance suggests that a church which purports to engage only in issue advocacy may in some circumstances violate the ban if it focuses only on a narrow range of issues that the church is most interested in. I consider this muzzling of the voice of church bodies, particularly church pastors, unacceptable. And I am very fond of the quote of Professor Schmalbeck in his paper on page 3. The rules seem to say free expression by churches is fine except when it might actually matter. I wish I had come up with that quote in one of my papers already. He's right. Now, it is also the case that the ban itself requires a level of entanglement between church and state that is egregious. Now, think about it. As interpreted by the IRS, the ban requires the agency to monitor and decide such matters as whether a pastor is speaking on behalf of himself or on behalf of a church, whether a sermon or newsletter discussing pressing moral issues of the day is really a disguised endorsement of a candidate, whether a forum for candidates sponsored by a church features sufficient breadth of questions, and whether a church has invited a public figure to speak in a candidate or in a non-candidate capacity. I guess it depends on which hat the candidate is wearing. Policing these messages and invitations to speak never ends, and it theoretically requires the agency to scrutinize every word of a sermon and to monitor every guest in a pulpit according to the way the agency interprets the statute with which it is charged to administer. So, do compelling arguments justify the ban itself? And in numerous pieces of scholarship, I argue and explain why the answer is no. Also, however, I share the concern that lifting the ban entirely with no further restrictions would also create unacceptable problems. The risk of entities that are not really functioning as a church, for example, or that are borderline functioning as a church to serve as mere conduits. So when I tell you that I think that the ban should be lifted, I am not telling you that I think that churches should have free rein in electioneering. That is also very problematic. What I'm saying is it's a false choice. It is not correct to think that one must embrace current law's ban or else have a free-for-all. There are lots of other possible solutions. Now, Professor Schmalbeck has one creative solution. I was glad to hear that what you really favored was the elective option rather than just saying all churches would be, because I had some concern with the view, I had greater concern with advocating that all churches had to be funneled into this special category. I think that there's room to work with this as an elective option. I think there's some other very good options as well. Now, what I'd like to do in the last couple of minutes, is to lay out the case why the better view, not the only view to be sure, but why the better view for Establishment Clause purposes is that the charitable contributions deduction and the charity income tax exemption do not effectuate a governmental subsidy for purposes of the religion clauses. And I want to argue this both as a descriptive matter and as a normative matter. And then in my follow-up time, I want to argue in favor of this as a very practical matter as well. So let me address it from a constitutional perspective first. Professor Schmalbeck talks about some cases that could lend credence to the view that, well, it really is a subsidy, right? But the cases that are cited in the paper as supporting the view that it's a subsidy for constitutional purposes do not support the view that it is a subsidy for all constitutional purposes. And the precedent under the Establishment Clause is actually quite deep, that when subsidies are indirect and whatever benefits flow primarily from the choices of private actors rather than governmental bodies, we do not have an Establishment Clause violation. Now, the tax case that people are most familiar with, it establishes this position, is Waltz, and it involved property tax exemption. But it is not the only relevant case. In addition to Waltz, we have some opinions like the Mueller case, where the court upheld the constitutionality of a state income tax law permitting a deduction for payments of school tuition, private school tuition, and books, even though in the state most of the kids that were going to the private schools were going to religious schools. Okay. Why? For constitutional purposes, under the Establishment Clause. Why? Because the private choices of individuals were what determined whether or not kids would go to the private schools. And it's not just tax cases where you see this. You see this in some more direct subsidy kinds of cases, like vouchers. And again, the thread common among these Supreme Court cases is that when the indirect subsidy, if there is one at all, is primarily effectuated through private choices, for Establishment Clause purposes, we should not attribute those choices to state actors. My position is that with this quite extensive body of Establishment Clause jurisprudence, tax and non-tax, there is a strong descriptive case that there is no Establishment Clause problem with allowing churches to receive tax-deductible contributions. And furthermore, I believe that not only descriptively for Establishment Clause purposes can you make this a strong case, I believe that proscriptively you can as well. I wish I had about an hour to set forth all of this, but I understand that there is a very well-received tax professor here who has a class right after this presentation, and he actually wants to teach some basic income tax. So I'll step down and let him have the floor for his next 8 to 10.
Right. Yeah. Okay. Right. Yeah, I know we're just about out of time, and I would like to leave a little time for questions. So, there's just a little bit of a ships passing in the night quality to the conversation, because I was trying to limit it just to the political speech question and made only passing reference to the constitutional arguments. It is true that in the paper that I have, which you can see also if you'd like, there's a major section that's devoted to the constitutional analysis. And if the debate had been primarily on that, then we probably would have had a debate. We would have been able to disagree a little bit more. As to political speech, we seem not to disagree
Not
very
much.
And I thought that was the case based on our writing. So I encouraged the society to cast it as a discussion rather than a debate because, A, I didn't think that we disagreed very much, and B, because if it was a debate, then as the one who suggests that maybe churches should lose their ability to get deductible contributions, I would clearly be speaking for the Prince of Darkness in that debate, and I wasn't interested in having that role. I don't know, should I if we had more time, it would be fun to take on the constitutional aspects of this, because I do think there's a problem there, and that's part of what my paper argues. And I may have slightly misdescribed my own paper, perhaps to your disadvantage, because I think if you are worried about the constitutional problem, if you take that seriously, then it would not be elective. This would not be an alternate option available to churches who want to speak, to forego the charitable contributions. It would be something that would be mandated for all churches. So you're not wrong in thinking that part of my paper does seem to militate in that direction. I think that's all I'll say at the moment, so we can leave a little bit of time for some question and answer.
Okay, well, maybe just so that we won't...
1:30 is when we're supposed to be done, actually, not 1:45, if that's what you're thinking.
Well, just so that our ships don't totally pass, let me lay out some reasons why, as a practical matter, aside from the constitutional arguments that I don't think there's an Establishment Clause violation, let me lay out some arguments that, as a practical matter, I think that some of the premises in favor of viewing church donations as being subsidized through the charitable contribution deduction are at least debatable, okay? I'll do that. Number one, from the research that I have seen, as a whole, compared to other types of charities, churches as a class and big humanitarian fundraising type organizations like United Way and the American Red Cross tend to receive much more of their contributions from lower income individuals as a percentage of their total than to the higher cultural kinds of charities, education, symphonies, the arts, like that. Which means that of those who donate to churches, you're probably going to get a greater percentage of donations compared to many other types of charities coming from people who may not itemize their federal income tax deductions. If they don't itemize, they're not taking advantage of the charitable contribution deduction. Okay, that's point one. Now, do some rich people?
Just stick in a corollary there. It also means that it doesn't matter to them very much.
Oh, I agree. So we got to think about where that goes.
Would not be such a cost.
I agree.
Yeah.
And in fact, I think there's another reason. Okay. Now, I'm not going to tell you that I think if you go to church that you're necessarily a tither. Okay. But there are many people who still hold to their giving responsibilities as tied to the biblical tithe. Maybe they don't give 10%, but they have some percentage in their heads, okay, I really need to be giving this much to my church. I think that people who donate to churches probably think that way a little bit more than people who who do not donate to churches at all. And of those who do donate to churches, I think they think that way about their donations to churches more than they think that way about their donations to the homeless shelter, okay? That's kind of the image they have, some kind of percentage of income, right? Which means my suspicion, now this one is not backed on empirical research. This is one I would have to study further empirically. But my suspicion is that if we were to curtail or deny the charitable contribution deduction for those types of people, okay, actually, churches might not suffer much. The incidence of higher taxes might not fall on the churches. It might fall with just the donors themselves who'll have to figure out a way to continue to give in accordance with their prior patterns. And one interesting twist on this is the following. If church donors who also give to secular charities are suddenly poorer because they don't have a charitable contribution deduction anymore for their church donations, what will be the impact on their secular giving? Is it possible that for those charities supported by church donors who will continue to give as before a percentage of their income, will they suffer if we eliminate the CCD only for churches? I don't know. I just think that it's more complicated than we might at first think, and we need to think through that possibility.
Questions? Please open up for questions.
So moving away from churches and talking about secular charities and their political aspirations, their political speeches, or even universities, I mean, aren't I receiving that same 40% subsidy if I donate to like a specific department in university, which I know the department is going to churn out, policy papers that are very tilted towards a certain viewpoint? Is that allowed, and like how's that different from the subsidy I receive if I donate to a church?
Handle that or me?
You go ahead. If I disagree, I'll let you know.
Okay. I see where you're headed with this, and I think you're onto something, but maybe not. Let me just say. Let me put both sides, if I can, as quickly as I can. It's certainly true that there's been nothing remotely resembling the 50 church audit program that applies to universities.
Yep.
On the other hand, there is a much stronger, and so you do have universities, and I think universities are widely and not inaccurately perceived as being, on average, sort of left of center. And so I was talking about the kind of political salience of the church, and so it is appropriate to be concerned about whether there is a countervailing bias in the system that is not receiving as much attention from the IRS. Fair enough. On the other hand, there's also a pretty strong tradition of academic freedom in universities. And it's much easier, I think, for the general public to observe that a particular statement by a particular professor is his own mad ravings, if they think that's the right way to characterize it, that's not necessarily associated with the university. A little different when you're hearing it from the pastor of the church. The pastor of the church is clearly the spokesman of the church. It would be as if, Duke University has a vice president of government and public relations. If that person said, I'm speaking here as Duke's vice president for public relations, and I think you should all go out and vote for X. That's a little closer to the pastor analogy to me, and that they couldn't do under the law, and I don't think they do it. I've kind of put a foot in both sides of your comment, but I don't know if you want to weigh in on either side.
Maybe just a couple of quick things. One is your question about donations to universities. It raises not only an issue about, well, is there already some slant in the recipients of other types of charitable donations? Okay, it also raises the whole quid pro quo analysis that's in your paper. Okay, if under Hernandez, Supreme Court precedent, if we have a donation that's clearly structured as this for that, there's no charitable contribution deduction. Okay. Now, Professor Schmalbeck makes the point that, communities of churches do get some benefits internally for their donations, even if they're not structured as this for that. My point would be the same can be said of many other types of secular charities. And in some cases, it's actually stronger than with churches. It's just kind of ironic I'm making this point at a university called Duke. Do you think that the Duke family received any reputational capital, okay, when they funded so much? We have naming rights, and right now, under current IRS practice, that's not enough to disallow a charitable contributions deduction. Making yourself look like the greatest philanthropist of all history for the region, that's not enough to take away the charitable contribution deduction. Okay? Now, it's certainly true that two wrongs don't make a right, and you make the basic point. So maybe we need to rethink our quid pro quo analysis for the charitable contribution deduction. But I want to just hold the brakes a little bit and say, hey, we're going to do this. We need to do it across the board, not just for churches, for other secular charities as well.
Sure.
One more question?
They want to go too. Everybody has things to do.
Thank you so much to our speakers. Our next Federal